Chapter 38. Elements and incidents of the contract essential to specific performance. Analysis. Section 762. The jurisdiction discretionary. The object of the foregoing paragraphs is to formulate the general rules which determine the classes of contracts in which the equitable jurisdiction may be exercised. But even when a particular contract belongs to such a class, the right to its specific performance is not absolute. Like the right to recover a legal judgment, the granting the equitable remedy is, in the language ordinarily used, a matter of discretion, not of an arbitrary, capricious discretion, but of a sound judicial discretion, controlled by established principles of equity, and exercised upon a consideration of all the circumstances of each particular case. Where, however, the contract is in writing, is certain in its terms, is for a valuable consideration, is fair and just in all its provisions, and is capable of being enforced without hardship to either party, it is as much a matter of course for a court of equity to decree its specific performance as for a court of law to award a judgment of damages for its breach. This is the ordinary language of judges and text writers. The term discretionary as thus used is, in my opinion, misleading and inaccurate. The remedy of specific performance is governed by the same general rules which control the administration of all other equitable remedies. The right to it depends upon elements, conditions, and incidents, which equity regards as essential to the administration of all its peculiar modes of relief. When all these elements, conditions, and incidents exist, the remedial right is perfect in equity. So far as these essential elements and conditions do not relate to the existence of contracts binding in equity, they are nothing but expressions and applications of the fundamental principles. He who seeks equity must do equity, and he who comes into equity must come with clean hands. Section 763. Contract must be upon a valuable consideration. Equity will not decree specific performance of a contract except upon a sufficient consideration for the promise, such as would satisfy a court of law in dealing with a contract. It must be a valuable, and not merely a good, consideration, as blood and affection, and there must be a consideration in fact, and not merely one stated. And equity will never decree specific performance of a voluntary undertaking or promise. Equity goes further than the court of law, and looks behind the seal of a specialty, and will not give its aid to enforcing the sealed instrument if there is no consideration found. Section 764. Contract must be complete, certain, and definite. A contract that is incomplete, uncertain, or indefinite in its material terms will not be specifically enforced in equity. Following the general principles of equity, there is required a greater degree of certainty and definiteness for specific performance than to obtain damages at law. For specific performance is required that degree of certainty and definiteness which leaves in the mind of the chancellor or court no reasonable doubt as to what the parties intended, and no reasonable doubt of the specific thing equity is to compel done. The element of completeness denotes that the contract embraces all the material terms. That of certainty denotes that each one of these terms is expressed in a sufficiently exact and definite manner. An incomplete contract, therefore, is one from which one or more material terms have been entirely omitted. An uncertain contract is one which may indeed embrace all the material terms, but one or more of them is expressed in so inexact, indefinite, or obscure language, that the intent of the parties cannot be sufficiently ascertained to enable the court to carry it into effect. Section 765. Incompleteness of proof. Wherever the contract rests in whole or in part on parallel evidence, the elements of incompleteness, uncertainty, and indefiniteness may exist when the proof is insufficient, conflicting, and leaving room for doubt as to what the precise terms were, for the plaintiff is bound to establish clearly and satisfactorily the existence of the contract and its terms. Section 766. How far parallel evidence can be used to make certain or definite. However, it is not required that the written contract itself should furnish the sole evidence of such certainty and definiteness, where it is complete in its material terms, and there is sufficient certainty and definiteness for the court to supply either by proper reference to other documents, or by properly admissible parallel evidence as to extrinsic facts. the necessary degree of exactness. But parole evidence can never be given to supply an omitted term or make definite and certain that which the parties left indefinite and uncertain. In a word, parole evidence cannot show the intent of the parties if it cannot be found in the contract. Parole evidence can only be used to fit the description to the land. Section 767. Incompleteness and uncertainty may relate to the parties, price, subject matter, conditions, etc. The material terms, or the existence of the contract, may be lacking in reference to 1. The parties contracting, or 2. The price or some definite means of ascertaining it, 3. The subject matter, 4. Conditions, etc. Thus, 1. The parties must be capable of being determined from the written contract, 2. There must be a price given, or some means of ascertaining it within the power of equity to enforce, 3. The land or other subject matter must be described with sufficient definiteness to identify it. Equity cannot give specific performance unless the thing or land is specifically determined. Thus, a contract to convey your lot, where the vendor owned 3 lots, is not enforceable, and parole evidence cannot be brought in to show the intent of the parties as to one particular lot. But, to give the classic instance, a contract to convey my mill where vendor owned but 1 mill, is good. Contract to convey lot 56, block 12, is bad for uncertainty, as there is no mental division of blocks, and one to convey a lot where vendor lived, the size to be determined later, is bad for indefiniteness. Not only must the specific thing be identified, it must be defined. A contract to take a certain tract of land or any other piece of defendant's land is too indefinite. But a contract which gave a right to select 50 acres out of a larger tract has been enforced. 4. Conditions, etc. The contract must be complete, definite and certain as to whatever conditions are annexed. Terms of credit were given, place of performance, time of performance unless a reasonable time is inferred, and other terms that are made by the contract. Thus, a contract to furnish a city with light, allowing the substitution of electric light for gas, but leaving the number and price of the electric lights for later agreement is unenforceable for incompleteness in a material term. Similarly, a contract to take milk from plaintiff is unenforceable where neither price, amount, time nor place of delivery was named by the contract. Section 768. Uncertainty and indefiniteness alone as a defense. Many contracts are unenforceable for uncertainty and indefiniteness alone, rather than on the ground of incompleteness, or for these 3 elements combined. Thus, where a daughter let her father have a sum of money to purchase a home in exchange for his promise to leave it to her by will, and 5 years later the father bought a home, she was refused specific performance because of the indefiniteness. Where the agreement was for certain lots in either Section 8 or 9, there was no incompleteness of the contract, but there was such uncertainty that equity could not enforce the contract without making a new contract itself, which it always refuses to do. Section 769. The doctrine of mutuality. The rule restated. The frequent statement of the rule of mutuality, that the contract to be specifically enforced must as a general rule, be mutual, that is to say, such, that it might, at the time it was entered into, have been enforced by either of the parties against the other, is open to so many exceptions that it is of little value as a rule. But in view of the firm place that the doctrine of mutuality has obtained in the courts of equity, it seems well to attempt a restatement that shall be more free from exceptions. The following form seems to meet the cases generally. If, at the time of the filing of the bill in equity, the contract being yet executory on both sides, the defendant, himself free from fraud or other personal bar, could not have the remedy of specific performance against the plaintiff, then the contract is so lacking in mutuality that equity will not compel the defendant to perform but will leave the plaintiff to his remedy at law. This rule, it is believed, covers the circumstances in equity where, according to the weight of authority, the court refuses its aid for lack of mutuality. So far as there is a principle of mutuality, it is a mutuality of remedy in equity at the time of filing the bill that is required, and not a mutuality in the terms of the contract when the contract is made. Equity is entirely willing to grant plaintiff the performance he applies for, but if it finds that in doing so the defendant, without fault, is left in turn to a remedy at law only, it refuses to lend its aid to such an unequal result. Therefore any original lack of mutuality in the terms of the contract will have no influence if the court finds that giving the plaintiff his relief will no longer leave the defendant to the law for relief. Keeping in mind this general principle enables a ready disposal of the so-called exceptions to the rule of mutuality. These cases will now be considered. Section 770. 1. Contracts whose terms are not mutual. A. Where plaintiff could avoid performance. Where a contract for the sale of lands is signed only by the defendant, it is clear that the plaintiff need never have performed his agreement. There was a clear lack of mutuality in the terms. Yet it was early held that the contract could be enforced against the party who had signed. The cases all agree upon the point. The filing of the bill made the remedy mutual. From that moment the defendant would not need to trust to the law for damages. The principle is consistently applied throughout. Thus, an infant cannot have specific performance, for the filing of the bill by his next friend does not bind him, and the lack of mutuality still continues. But if the infant on reaching his majority files the bill on his voidable contract, he may now have specific performance, for any lack of mutuality is thereby cured. The remedy has become mutual. Similarly, where a husband and wife seek to enforce their contract against the vendee, although no mutuality existed before, the vendee being unable to compel performance, the filing of the bill makes the remedy mutual, and equity is satisfied. Section 771. B. Where plaintiff's non-enforceable promise has been performed. There is a considerable class of cases where equity cannot compel performance of plaintiff's undertaking from the incapacity of the parties, or the nature of the plaintiff's promise. Of such character are agreements for personal service, agreements to care for and support the defendant, agreements to furnish the services, or securely assent, of third persons, agreements calling for the exercise of skill, taste, and discretion of the plaintiff, various kinds of agreements calling for continuous acts, for building, and agreements where plaintiff's promise is too indefinite for equity to compel its execution. So long as such a contract remains executory, the filing of the bill does not make the remedy mutual, and in these cases equity refuses specific performance against the defendant because of the lack of mutuality, in fact, because it would leave defendant in the unjust position of having no assurance of performance on plaintiff's part. But that equity is concerned only with the mutuality at the time of filing of the bill is clearly shown by those cases where the contract is executed on plaintiff's part. The terms are the same, but defendant would no longer need to trust an inadequate remedy at law, and equity compels him to perform, as, where plaintiff agreed to work for defendant a certain length of time, and defendant to make conveyance at once. Before plaintiff has performed the personal service, he could not have specific performance, but after his part is executed, he can get the land. Section 772. C. Where plaintiff's inability is cured before decree. A clear instance of this sort is the inability of the plaintiff to make a title, because the title is in another. The defendant may have known this at the time of the bargain. Equity will not compel him to perform before the title is in, but should the plaintiff get in the title before the decree, defendant must perform. Section 773. 2. Unilateral contracts. Options. Unilateral contracts have really nothing to do with any rule of mutuality. Before the act which constitutes the acceptance is completed, there is no contract for equity to consider. After such act is performed, and there is a unilateral contract, there cannot be any question of mutuality, as the promisor has already obtained his advantage and is bound to perform his part. Courts of equity often speak of enforcing an option as if such enforcement were an apparent exception to the rule of mutuality. In fact, mutuality has nothing to do ordinarily with contracts of option. The option is only a binding offer. The promisor has parted with the right to withdraw his offer. There is nothing to enforce in equity before the exercise of the option, as the promisee has already obtained his right to have the offer kept open. Upon the exercise of the option, i.e., the acceptance of the offer, and the filing of the bill by the promisee would be one way of exercising it, the option ceases as an option, and equity has an ordinary bilateral contract to deal with. Thus it is usually said that an option to renew a lease is enforceable at the will of the lessee having the option. In fact, the lessee must first exercise his option, and then he has a binding contract for the renewal, and not an option. It can make no difference that defendant has tried to withdraw the option. He bound himself not to do so. This view is further supported by the enforcement of an exercised option which was under seal, and without actual consideration. The offer being under seal cannot be withdrawn. Upon its acceptance, the court cannot be concerned with the lack of consideration, which is a good defense to specific performance in equity, for it is the contract and not the option that is being enforced. There is a class of option contracts that are not in the nature of a mere binding offer which may be made into a bilateral contract by the exercise of the option, but are themselves bilateral contracts for a privilege which may be exercised by the promisee, but which he is under no obligation to exercise. These options are usually for mining or prospecting privileges, where the option is so worded that the exercise of the privilege may be delayed indefinitely. Specific performance is refused, and the refusal is sometimes based on the ground of lack of mutuality. In such cases the right obtained by the option, to prospect or not, since it keeps the defendant out of the use of his land for an indefinite time, is bad for inequality and indefiniteness rather than for lack of mutuality. Section 774. Contracts terminable at the will of one party. Some courts have refused to enforce contracts by the terms of which the plaintiff can at pleasure put an end to his obligation, on the ground that the remedy was not mutual, as the plaintiff could always defeat specific performance against him, either before the decree by terminating the contract, or after the decree by rendering any decree against him nugatory by terminating his obligation. Thus, in a lease of a mine for exploration and working, the plaintiffs had the right to terminate the lease on 30 days' notice. Specific performance was refused, for lack of mutuality. But the better view is that by the Circuit Court in Singer Sewing Machine Company v. the Buttonhole Co. There the court held that the objection of lack of mutuality would not prevent the enforcement of the contract, so long as it was actually kept alive by plaintiff's continued performance. Section 775. Indirect enforcement by enjoining the breach of defendant's negative covenant. A similar objection, for lack of mutuality, is urged to the indirect enforcement of a contract by an injunction against the violation of a negative clause of the defendant's agreement, where neither the defendant nor the plaintiff could have specific performance of the affirmative side of the agreement, as in the case where defendant agrees to sing in plaintiff's theatre, and in no other place. But the answer of equity is conditional decree, an injunction which is good so long as plaintiff continues to do his part, but dissolvable upon his failure to perform. While a clear lack of mutuality exists in the terms of the agreement, inasmuch as one of the terms is unenforceable in equity, yet the final test shows that the remedy of a conditional decree does not leave the defendant to a legal remedy, as plaintiff must give performance so long as he receives it. In Hills v. Kroll the court refused to grant the injunction against breach of the negative covenant on the ground of lack of mutuality, as it could not enforce the affirmative part of the agreement. But the case is inconsistent with the ruling case of Lumley v. Wagner, as since pointed out by the English judges, and cannot be now regarded as sound. Section 776. Fraud or other personal bar of the defendant. There is no lack of mutuality, in the eye of equity, where the defendant's inability to enforce the contract arises from any inequitable conduct on his part, such as sharp practice, fraud, concealment, unfairness, etc., which creates a personal bar against his obtaining specific performance. His lack of remedy from his own act is no defense to the complainant's petition. Section 777. Mistake, rescission and reformation. As mistake is no defense in a court of law to the obligation under his contract, one must look for relief, if at all, in equity. For certain kinds of mistakes equity will give the affirmative relief of rescission, or reformation with specific performance. For other kinds of mistake only the negative relief is given of a refusal to decree specific performance against the defendant, setting up the defense of mistake. And in many cases of mistake, no relief of any kind is obtainable. The affirmative relief of rescission or reformation is given, generally speaking, in cases of mutual mistake, either where the mistake was in the formal deed or contract, which by mutual mistake or a mistake of the draftsman, fails to correspond to the real agreement, in which case a reformation is usually decreed, often with specific performance, or where by mutual mistake the agreement itself does not express what the parties intended, in which case there may be a rescission, or under some circumstances reformation of the intended agreement. But we are here more particularly concerned with that class of mistakes which only serve as a defense to a suit for specific performance. Section 778. What mistakes are a defense to specific performance? In the cases of mistake, as in other matters in equity, it is plain that a set of circumstances insufficient to give a right to the radical step of rescission, in which all rights in law or equity are cancelled, may well be sufficient for equity, using its discretionary power, to refuse its aid to enforce the contract against the party making the mistake, although it will not protect him from the consequences of his contract in law. Mutual mistake which gives a right to reformation or rescission, would of course give a right to the lesser relief of refusal of specific performance if the affirmative relief were not insisted upon. Usually, in the cases to be described, where relief is given, it will be found that the question is not purely one of mistake, but the related principles of hardship or unfairness, of sharp practice, or innocent misrepresentation, in combination with the mistake, determine equity to refuse its aid to the plaintiff, although the court may ground its decision on mistake. But there are certain principles of relief growing out of pure mistake which will now be examined. Section 779. Misdescription and ambiguity. Where the terms are so ambiguous that the defendant could reasonably, and did in fact, put a different meaning upon them than the plaintiff, it is clear there was never the requisite consensus ad idem, and no valid contract at law or in equity. But even where there is a sufficient consensus ad idem to make a contract valid and enforceable at law, if equity is satisfied that there was sufficient misdescription or ambiguity as to the substance of the contract for the defendant to be justified reasonably in the mistake made by him in understanding the particulars of the contract, equity will not decree a specific performance against him. Section 780. Mistake induced, or contributed to, by the plaintiff. Wherever the mistake was materially contributed to, or induced by the acts or words of the plaintiff, equity will not decree a specific performance against the defendant, if the mistake is material. The plaintiff's part in misleading the defendant, whether the plaintiff was innocent in intention or not, prevents him from casting the consequences of the mistake on the defendant by the aid of equity. Section 781. Mistake known to plaintiff. When the plaintiff knows of the defendant's mistake, or must reasonably suppose a mistake had been made, the circumstances are often such that the plaintiff cannot equitably ask a court of chancery to force a hard bargain due to this mistake on the defendant. A mistake which in itself might not be sufficient ground to save the defendant from his bargain, may often protect the defendant when the plaintiff knew of the advantage he was getting when the contract was made. Section 782. Mistake due to defendant's negligence. Where the court is satisfied that the mistake is due to the defendant's culpable negligence, it will not, as a general rule, accept the mistake as a defense, the plaintiff not being barred himself by any act of inequitable advantage. Section 783. Mistake due solely to defendant. The most difficult cases are those where the mistake is due solely to the defendant, without negligence on his part, or inducement or advantage taken by the plaintiff. It is plain that not every material mistake in such a case will enable the defendant to avoid performance of the contract. The rule may be stated that where the mistake is solely due to the defendant, but without his fault, equity will refuse specific performance only where the mistake is of a vital part of the contract, of the corpus of the agreement, and of such nature that enforcement would be a great hardship. Thus, it is said by Justice Fry that for a mere mistake in acreage equity will not refuse specific performance. The mistake is not one which goes to the corpus with which the court deals. It is not a mistake as to the essential part. A mere difference in quantity has never been held to be a bar to specific performance. Where the mistake is such that the whole contract is one the defendant had no intention of entering into, as where the defendant bid in one lot of land thinking it was an entirely different piece, equity will not compel him to perform the agreement, neither will it where the mistake, though not total, is so great that it should have suggested to the plaintiff that a mistake had been made, or if that element be lacking, where the difference arising from the mistake is so great that the defendant is subjected to an entirely different operation of the contract, hard and oppressive upon him. It is thus apparent that in most cases of mistake solely due to the defendant, the court is finally governed by the principle of hardship and unfairness equally with that of mistake. Where the defendant's mistake is solely due to a failure to make an enquiry which he was bound to make, he cannot object to the results of his negligence, and performance will be given against him. Section 784. Concealment or non-disclosure of material facts as a defense. The doctrine of equity relating to those fraudulent concealments which furnish a basis for the remedy of rescission or cancellation, and, a fortiori, a defense to specific performance, has been fully described elsewhere. It was there shown that such concealment, as distinguished from misrepresentation, is, in general, a ground for avoiding the contract only where it involves the breach of some fiduciary duty to disclose the whole truth, a duty arising either, 1. from a pre-existing relation of confidence between the parties, or, 2. from a confidence reposed, by one party in the other, in the particular transaction in question, or, 3. from the essential nature of the contract itself. It was also there intimated that the mere non-disclosure of a material fact known only to one party, in circumstances that do not afford sufficient ground for the cancellation of the contract, may nevertheless influence the court to refuse specific performance of the contract against the party who was misled. This view is supported by dicta of the highest authority, and by many decisions. And it may fairly be said to be a general rule of American equity that non-disclosure by the complainant of material facts, knowledge of which was obtained by superior facilities of information on his part, of which facts the defendant was ignorant, and was known by the complainant to be ignorant, is, in connection with marked inadequacy of consideration, sufficient to render the contract too unfair and unconscionable for specific enforcement. Section 785. Unfairness and hardship as a defense to specific performance. The contract must be perfectly fair, equal, and just in its terms and its circumstances. The contract and the situation of the parties must be such that the remedy of specific performance will not be harsh or oppressive. If, then, the contract itself is unfair, one-sided, unjust, unconscionable, or affected by any other inequitable feature, or if its enforcement would be oppressive or hard on the defendant, or would prevent his enjoyment of his own rights, or would work any injustice, or if the plaintiff has obtained it by sharp and unscrupulous practices, by overreaching, by trickery, by taking undue advantage of his position, by non-disclosure of material facts, or by any other unconscientious means, then a specific performance will be refused. It necessarily follows that a less strong case is sufficient to defeat a suit for specific performance than is requisite to obtain the remedy. The oppression or hardship may result from unconscionable provisions of the contract itself, or it may result from the situation of the parties, unconnected with the terms of the contract or with the circumstances of its negotiation and execution, that is, from external facts or events or circumstances which control or affect the situation of the defendant. The foregoing statement of the equitable doctrine of hardship is best understood by an analysis of the circumstances where equity has found that kind and degree of hardship which leads it to refuse its aid. Such analysis indicates that the hardship which defeats specific performance usually arises from one or more of the grounds following. Section 786. Unfairness and advantage. The plaintiff's conduct may amount to a personal bar to specific performance, as in the cases of sharp practice, concealment, contrivance, etc., or even if he is not barred by inequitable conduct, he may have obtained the contract under such conditions of advantage, that equity regards it as unfair, and its enforcement a hardship. Such cases arise where the plaintiff takes advantage of the condition of the defendant, as of his pressing necessity, to drive a very hard bargain. Section 787. Inequality. Even though the plaintiff was free from intention to take an unfair advantage, if the actual result is an inequality and unfair advantage, equity will not aid the plaintiff. The inequality which equity regards may be of two kinds: a, that in the inception, existing when the contract is made, either between the parties or arising from the situation, as, where defendant acted under great and pressing necessity, or was otherwise at a disadvantage by reason of old age, mental weakness, poverty, ignorance, inexperience, sex, etc. Or, b, that inequality which the court of equity finds in the operation of the contract, as where the terms are so indefinite, unqualified, or assented to with such lack of caution, that their enforcement would produce an inequality not foreseen by the defendant. Thus, in the first instance, a, where a buyer dealt with an aged invalid woman, without male advisers, although the buyer used no undue influence, took no advantage, and gave a fair price, he was refused specific performance as he had not taken the precaution to call in male advisers to render their situation equal. b, of the second type, inequality in operation, is that class of numerous oil lease cases, where for a slight consideration and an agreement to give royalties, the plaintiff has the right to prospect for oil on defendant's land, and no time limit is set upon this right, as he is not obliged to make any prospect, and may indefinitely keep the defendant out of the use of his land. The operation of the contract is so unequal that equity declines to enforce it. Section 788. Intoxication. Complete intoxication, such that the defendant had no comprehension of his act, that extreme state of intoxication that deprives a man of his reason, would be ground for complete relief in equity, rescission, as well as a defense to specific performance. Ordinary intoxication is not a ground for rescission where the plaintiff did not cause it or make it a means of fraud, but it generally has the effect of neutralizing the equities of the parties, in a suit for specific performance, so that the court will not act on either side. As the Master of the Rolls, Sir William Grant, said, a court of equity ought not to give its assistance to a person who has obtained an agreement or deed from another in a state of intoxication, but, intoxication which merely exhilarates and does not materially affect the understanding and the will, does not constitute a defense to the enforcement of an executory agreement, and much less is it any ground for affirmative relief. Section 789. Improvidence of the undertaking. Under some circumstances, especially where any inequality exists between the parties, a highly improvident contract will not be enforced, as in the instance of a widow without capital agreeing to purchase an estate for $50,000, in installments. The court found it was so probable that she was undertaking an arrangement that could only end in disaster for her, that it would not force the bargain upon her. A better instance of pure improvidence without inequality is found in the defendant's undertaking to assign in gross all his future inventions. Equity refused to compel the observance of this agreement. Where a woman agreed to convey land valued at $1,200 for a horse worth $100, equity would not force her to convey the land. On the other hand, where no other element enters than a bad bargain or mere inadequacy in consideration, it is the rule in equity to enforce the contract. The mere fact that defendant entered into a losing bargain or one where plaintiff will reap great gains is clearly never a ground to refuse specific performance. Section 790. Inadequacy of consideration with other grounds. The usual statement of the modern rule is that mere inadequacy of consideration is not such hardship as will prevent specific performance, unless the inadequacy is so gross as to shock the conscience of the court and amount to decisive evidence of fraud. The earlier cases were inclined to make mere inadequacy a sufficient hardship to defeat specific performance, but this tendency was checked by Lord Eldon. In a few modern cases equity has refused relief on the ground of mere gross inadequacy, such disproportionate advantage to the plaintiff that it shocks the conscience of the court. But courts generally do not admit this exception, but do give much weight to inadequacy when coupled with other evidence of hardship, as some degree of inequality, improvidence, etc. Section 791. Unintended harsh consequence. Where the court is satisfied that the result which bears so hard upon the defendant, though legally a constituent part of the contract, was not intended by the parties at the time of the agreement, in fact, was not in contemplation as the effect of the agreement, which was expressed in terms too unqualified, it will not specifically enforce the agreement. Thus, where a lease of a waterfront and wharves contained a covenant to make all repairs, and a flood of the river washed away and destroyed the property to a large extent, specific performance was refused. Section 792. Inadvertent covenant, or act. Analogous to the case of unintended consequence, is that arising from mere inadvertence of act or covenant, as where a covenant-bound trustee is personally in a warranty of land sold under the trust. This was considered such an inadvertent assumption of a personal obligation that equity would not enforce it. Similarly, in an auction sale, by an inadvertent act of a third party, there was a suppression of the bidding. Specific performance was therefore refused. Section 793. Greatly oppressive consequence. In rare instances the mere onerousness or oppressiveness of the consequences of enforcement may be so great that although there is no other reason, equity will not grant the performance that plaintiff is otherwise entitled to, as, where, by the clause of a certain will, the sale of the land would cause the loss to defendant of one half the purchase money, a large sum. But generally speaking, where the defendant entered upon the contract with his eyes open, the hardship arising from collateral circumstances cannot give him a defense. Section 794. Injury to third persons. Where the contract would be hard, unjust, and oppressive to innocent third persons, who have an interest in the subject matter, equity will not enforce the contract, as, where the third person has a vested interest in the property which would be injuriously affected or defeated, as, a remainder man, reversioner, etc. In the English law. An extreme illustration, of doubtful validity, is found in a case where an unmarried man contracted to leave by will all or the greater part of his property to the complainant, and later the promisor married, and died intestate. Equity refuses performance of the contract, as it observes that the natural right of the wife to be protected has intervened, and equity will not assist in divesting her of the property, but will leave the complainant to his legal remedy. Where a conveyance of a lot, which projected beyond the common line of the neighboring lots 10 feet, would inflict unnecessary injury to the adjoining proprietors, the court refused its aid to enforce the contract as made, but gave the vendor the option to accept conveyance of a lot with boundaries conforming to those adjoining, with compensation for the deficiency. Section 795. Inconvenience to the public. Where the consequence of enforcement of the contract is to inconvenience the public, the discretionary power of equity is exercised to refuse its aid. This rule is frequently applied in contracts by which a railway has bound itself to do some act, as to build a private grade crossing, or stop its trains at complainant's place. If the public service would be endangered or inconvenienced, with no corresponding benefit to complainant, he cannot have performance. But not every slight inconvenience to the public will be a reason for refusing performance. Section 796. Performance no benefit to plaintiff. Specific performance not being an absolute right, the fact that enforcement would be of little or no benefit to the complainant, and a burden upon the defendant, is sufficient to constitute performance oppressive, and it will not be given. The disproportion between the burden upon the defendant and the gain to the plaintiff makes performance inequitable. Instances are found in the cases of restrictive covenants on land, where, the character of the neighborhood having changed, as, from residence to a business neighborhood, the whole purpose of the covenant is gone, and enforcement would be of no benefit to complainant. Section 797. Subsequent events, which should have been contemplated, no defense. Courts of equity frequently state the rule to be that the hardship and unfairness must be judged of in relation to the time of making the contract, and that specific performance will not be refused because of hard conditions brought about by subsequent events, or changes in circumstances. A more accurate formulation of the rule is this: equity will not relieve against hardship arising from a change in circumstances or the result of subsequent events, where these should have been in contemplation of the parties as possible contingencies, when they entered upon the agreement. And of such nature are the ordinary changes like a rise or fall in values, profit or loss in the undertaking, mistakes of judgment, unforeseen events, which yet were fairly possible contingencies, etc. Thus, No hardship arising from a great change in values between the time of making of the agreement and the conveyance can be a ground for any relief, nor can hardship arising from bad judgment, miscalculation, or changes of conditions that ought fairly to have been in contemplation of the defendant be considered by the court. Those results of the contract are what the complainant has a clear right to receive, and defendant no equity for refusing. Thus, in a contract to lease a feeder line of railway for a number of years, with a covenant to keep the line in operation, the fact that the line has ceased to pay, and to operate it means a continued loss for several years, is no defense to a suit for specific performance. Section 798. Subsequent events, not in possible contemplation, often a defense. Illustration of such events may be found in cases where after the contract has been made, costly street improvements are ordered by the city, which enhance the value of the land, but fall as a burden upon the vendor, and equity will not give the vendee the land unless he will assume the cost of the assessments. The leading case of Willard v. Taylor L. refused to compel a vendor to accept greatly depreciated paper, currency, legal tender, which by both the general terms of his contract and the general law he was bound to do. In another instance, where the vendor had remained in possession and paid the outgoings for a long time after the contract was entered upon, and the land had nearly doubled in value, performance was refused on the ground that as vendor's expenses had been so great, equal to about one-half the contract price, he would receive practically nothing for his property, and it would be against justice and conscience to compel him to convey it. Where there is delay on the plaintiff's part in claiming his rights, and changes of conditions may make specific performance an injustice, it will be refused. Section 799. Direct act of either party. Where the hardship arises from defendant's own act, after the bargain, he cannot complain of the results of his own conduct. The defendants cannot be permitted to avail themselves of impediments of their own creation. On the other hand, when the plaintiff's own conduct is the cause of the hardship defendant would incur by performance, and his conduct is not equitable, he cannot ask the aid of equity, as where the plaintiff allowed the insurance to expire just before the time of conveyance, gave no notice to defendant, and the house burned. The vice-chancellor held the complainant's conduct, though unintentional, and although not in violation of any legal duty, yet operated as a trap upon the defendant, and equity would not give its aid to the vendor. Section 800. Forfeiture. When the performance of a contract will render the defendant liable to a forfeiture, the performance is a hardship, within the meaning of the general rule, and will not be decreed. If, however, such liability is not a necessary, or natural effect of the agreement when originally made, but arises from the subsequent acts or omissions of the defendant himself, it will not avail to prevent a specific enforcement. Section 801. A purchaser need not accept a doubtful or unmarketable title. The rule is now well settled that equity will not compel an unwilling purchaser to accept a doubtful title which will expose him to the expense and hazard of litigation. It will not force him to buy a lawsuit. He need not take the title unless it is marketable, i.e., merchantable, free from any defect that will affect its value in the eye of subsequent purchasers from the vendee. That may be a good title in law which a court of equity in the exercise of its discretionary power will not force on an unwilling purchaser. Every purchaser should have a title which shall enable him not only to hold his land, but to hold it in peace, and if he wishes to sell it, to be reasonably sure that no flaws or doubt will come up to disturb its marketable value. But a threat or even the possibility of a contest will not be sufficient. The doubt must be considerable and rational, such as would and ought to induce a prudent man to pause and hesitate, not based on captious, frivolous, and astute niceties, but such as to produce real bona fide hesitation in the mind of the Chancellor. Section 802. The standard for determining a doubtful title. While the general rule that equity will use its discretionary power and decline to force a doubtful title on a purchaser is everywhere recognized, there has been a considerable conflict of decision as to what principles should determine the doubtfulness of the title. It was early recognized that the title might be doubtful, 1. Because of doubt as to the general law or the construction of a statute, on which the title depended, or, 2, because of doubt as to extrinsic facts or the construction of an instrument which affected title. The leading case of Pike v. Waddingham held that as to matters of general law, the court was to judge whether the general law upon the point was or was not settled, and to refuse specific performance where it was in doubt as to the law, on the matter of construction, or in doubt as to extrinsic facts affecting the title. And that even where the court thought the title was good, yet if it thought that other competent persons might well entertain a contrary view, it should hold it doubtful and refuse to force it on the purchaser. Section 803. 1. Where the doubt arises from an unsettled question of law. The later case of Alexander v. Mills seemed to limit this broad view somewhat by making the court decide the doubt as to the law, not only where the general law was settled, but to ascertain and determine as best it may what the law is, and to take that to be the law which it has so ascertained and determined. This course obviously compelled a buyer to take a title that might not be marketable if another court took a different view upon the disputed point of the general law. It was natural for the courts to reach ultimately a sounder conclusion, which was soon done. The true modern rule was worked out in re Thackeray, that the court does decide on general matters of law, including the construction of Acts of Parliament, about which there cannot be fairly said to be any judicial doubt. But in order for it to be right for the court to adopt its own view of the law in resolving the doubt, it must appear to the judge who decides it that there are no decisions or dicta of weight which show that another judge or another court having the question before it might come to a different conclusion. The American cases follow this later rule of in re Thackeray. Section 804. 2. Where the doubt arises from an extrinsic fact or the construction of a document. As to what facts or questionable documentary constructions render a title unmarketable, only an examination of many instances can be of utility, having in mind the test stated above. Such defect entitled that an ordinary subsequent buyer in the market would be unwilling to accept it at full value. For this reason, a number of cases with the particular defect found by the court are collected in the note below.